Outrageous inefficiency. Common and statute law in Australia depends upon the ability of judges and juries to guess what might be on the mind of the opposite sex. With a solitary men's jurisdiction, the delivery of justice is so appallingly inefficient that only the privileged have access to a fair outcome. The Constitution of Australia, which establishes the courts, recognised men's inalienable right to make decisions about their own lives without fear of interruption or intimidation at inception. It did not, and in the absence of reform does not, recognise that women have this same right. No provision has ever been made for either a women's legislature or a women's jurisdiction at law. It is an utterly sexist, discriminatory and unquestionably inappropriate and grossly inefficient and ineffective document in the governance of the nation. A document serving the interests of men exclusively. In absence of the recognition of a collective women's mind, and with the presumption of alienation of women at promulgation, the Australian Constitution invests men only with power, regardless of women's participation in legislatures and the law. A women's court is best equipped to deal with a female applicant or defendant, yet the only courts available are those set up by men, to which women are invited so long as they don't assert that women, collectively, think differently from men, or that what's on a woman's mind is more justly considered by another woman. Relations between women and men are the basis of society. The state of the mind of the applicant, witness or defendant is the basis of law. Configuring society with the law equitably is the basis of justice. With the provision of both women's and men's legislatures and jurisdictions, the women and men who make the rules and deliver judicial decisions will, as they do now in the men's legislatures and jurisdiction, consider each other when making laws and delivering decisions. When disputes of sufficient animosity arise between the rules and decisions women and men make, elders may intervene. Moreover, the judiciary is not sufficiently inept as to be unable to configure existing resources according to the essential nature of the service its members provide. The efficiency outcome obtained by clearing up the massive confusion of a system based on guesswork should provide all people with access to justice, not just corporations with sufficient funds to buy justice, as is the current approach. Streamlining the delivery of justice with constitutional reform providing for women's and men's legislatures, presided over by an executive of elders, accompanied by courts of women's and men's jurisdiction, is essential to the future of the nation. This is Philip McKeown for 2mf.net News.